All right, so let's get started. Thank you everyone for coming to this month's CodeX Speaker Series. Our speaker today is Professor Kevin Ashley from University of Informatics here at Stanford. We're a joint center between a law school and the computer science department. Our mission is to use information technology and make the legal system more efficient for all the stakeholders in the legal system. And so one of our core interests is computational law. By that we mean, Cis Bill, one of the people who's really, some of the most foundational work in that space is Professor Ashley. I will leave it to our fellow Professor Bart Verhey, who's visiting us here this year from University of Groningen, to introduce Professor Ashley to you, since he really is most familiar with his work. Just wanted to let you know that at 3 o'clock in the Newcomb building, room 102. So you're welcome to join us anytime if you want to join the group, or you have projects that you want to introduce to the group and you want to sort of connect with like-minded people. Please join us every Thursday, 3 o'clock. So with that, I'll just turn it over to Bart, who will introduce our speaker.
In particular, his work on the role of hypothetical cases in reasoning with precedents has become a cornerstone of the field by showing the intricacies of the principle of stare decisis. And he empirically tested his approach by the development and validation of skills training programs, about which he may tell something, but I don't know that. Conference is the Jurix conference in Bologna, Italy, where the meeting was excellent. And his research ambitions remain where they should be, high. So today he's telling us about the computational modeling of legal texts. And if I know him well, he'll not only show us what can be done today, but will also explain how a serious research investment in the area can extend what is possible. So,
Mike Genezareth, and thank you, Bart, for that very kind introduction. And while I'm acknowledging people, I'd like to acknowledge my collaborators, Vern Walker at Hofstra University Law School, my PhD student, Matthias Grotmeyer, Professor Eric Nyberg at Carnegie Mellon University, and a variety of colleagues at the School of Public Health. So I've been involved with developing computational models of legal reasoning for over 25 years, as have many others in the AI and law research area. And I'd like to just give you a thumbnail sketch of where the field of AI and law is now with respect to computationally modeling law. The focus today is on AI and law computational models of argument. The field recognizes that legal reasoning is non-monotonic. That is to say that inferences change once the information is added or becomes invalid, that new evidence and source material change a legal argument. The field recognizes that legal reasoning is defeasible. There are conflicting arguments, and they defeat each other. Claims need not be true, but only satisfy some proof standard. The field recognizes, or most of it does anyway, that logic is not an ideal representation for legal reasoning. And so the solution has been to create computational models of argument, where the models support attacking and supporting arguments instead of strict inferences, and where the semantics are inference methods associated with patterns of conflicting arguments that are more or less domain-specific subcomponent argument models, referred to as legal argument schema nowadays, and where the overall computational model of argument provides some additional structure, like supporting the proof standards. And if you're interested in more, I suggest you take a look at the Carniades program. And so the work that many of us have done over those 25 years, work on argument models of reasoning with cases, of reasoning with rules, including Bart Verheye's model, of reasoning with rules and cases, starting with Anne Gardner's model. Anne is with us here in the audience today. Of reasoning with values, including new work by my student Matthias Grabmeier, and reasoning with evidence, including work by my colleague Vern Walker. All of those now are these subcomponents of the overall model of argument. These are the legal argument schema. And so the field has made progress in generalizing a theory that includes the work that's been done up to date in this overall model, integrating it into one overall model, but it still faces a major challenge: the need to integrate the computational models and legal texts. We've got all of these models for argumentation and some non-argument models, like models for prediction based on cases or network analysis of citations, but they don't connect in a natural way with the texts that we as lawyers all use and depend upon. That's our version of the knowledge representation bottleneck. And it's not just a problem of the huge time and effort required to represent the knowledge, but it's a problem of ingenuity. What types of information to represent, how to annotate the texts manually and automatically in terms of these types of information, how to classify new texts in terms of the types, because these types are going to be the connections, the intermediaries between the text and the computational models, and how to derive interpretations from these layered objective type annotations. That's the challenge that I'd like to address today. And I think you can see the magnitude of the challenge with a little comparison of one of those AI and law models, the SMILE plus IBP model, which predicted outcomes of cases and generated an argument in support of the outcome, and your favorite legal IR system. So the AI and law computational model is great in some sense. It represents legal concepts. It can automate similarity assessment between problems and cases. It deals with legally relevant similarities. It can compare the facts of cases in an automated way. It can support legal inference and argumentation. It can predict outcomes. It can tell you who won. Most legal information retrieval systems don't know who won the cases in their databases. It can automatically identify the issues, but it deals with hundreds of cases, tops. And the legal information retrieval systems that can't do all of that kind of thing nevertheless work well enough to solve some very practical problems for legal professionals. And they deal with millions of cases, and the case entry is completely automated. And that conflict is to the great detriment of prospects for AI and law models. So in the talk, I want to tell you about two efforts that I've made with my colleagues in order to integrate computational models of legal reasoning and texts. I'm going to first briefly describe some challenges, then focus on the two examples to illustrate how I've tried to adapt to those challenges. The first example involves extracting information from case decision texts, moving legal information retrieval to argument retrieval. And the second involves extracting information from statutory texts in work to compare regulatory frameworks with statutory task network diagrams that I'll explain. And then I'll conclude. So these are the challenges in integrating computational models in legal texts. The first challenge is specifying some real-world problem-solving context and tasks to be served by the integration. Next, to develop a corpus suitable for that task. Third, to design text annotation schemes, a system of types to connect the text to the computational model's knowledge representations so that the programs can reason with the cases. Fourth, to annotate the corpus. This usually involves labor-intensive manual annotation, but hopefully it will be able to be automated or at least semi-automated in the future using machine learning from manually annotated examples, and I'll give an example of that in my second example. And fifth, developing measures for evaluating and improving how well the automated annotation works and how well the integration facilitates the tasks, including using machine learning of confidence scores so that the system knows how likely it is that the evidence that it has retrieved is relevant to the problem to be solved. So here's the first example from legal IR to AR, or argument retrieval. We think that commercial legal information retrieval system users, the users of Lexis and Westlaw, often want argument retrieval, retrieving not just sentences with highlighted terms, but arguments and argument-related information from those textual cases. Using a corpus of argument-annotated legal cases, we've conducted a baseline study of 2 legal IR systems, you can guess which ones, responding to standard queries. We've identified ways in which the IR systems do not meet the need for argument retrieval, and we illustrate how additional argument-relevant information could help. We sketch an AR system to retrieve arguments from legal decisions and specify a context and tasks where the benefits, if any, could be objectively measured. Our domain is a corpus of cases decided by the Court of Federal Claims, and the decisions have to do whether claims for compensation comply with the National Vaccine Injury Compensation Program. So plaintiffs have been injured by administration of vaccine. They can't sue the pharmaceutical company because they're insulated from liability, but under this national program, they can recover compensation for their injuries. These are decisions of special masters who hold hearings and who decide what evidence is relevant, evaluate its plausibility, organize the evidence, draw inferences, and make findings of fact. Under this compensation program, the claimant is compensated if and only if the vaccine caused the injury. And the Federal Circuit has issued a decision, the Alton decision, that lays out the rules for what that means, how you show causation. There are 3 requirements. You have to show that a medical theory causally connects the type of vaccine with the type of injury. You have to show that there was a logical sequence of cause and effect between the particular vaccination and the particular injury. And you have to show approximate temporal relationship existed between the vaccination and the injury. So our corpus is all 35 decisions in a 2-year period following the Alton test of causation and fact, with each decision approximately 15 to 40 pages per decision. And all of this has been compiled by Vern Walker at Hofstra Law School. Vern has also created a computational model of legal reasoning in this domain. It's called the Default Logic Framework, and here you see an excerpt of a partial rule tree for the vaccine decisions. And this rule tree contains the requirements of the rules all the way from the statute on down, including the rules, the court-made rules, with respect in particular to causation. And here are those 3 requirements. And the logic in the statute with respect to combining these various requirements. Then they have taken each of those cases and they have basically connected to the leaf nodes of the decision tree each case annotating the case in terms of the evidentiary fact findings that the special masters regarded as sufficient for deciding that that statutory or court-made rule requirement was satisfied or not. And so once having annotated the decision-making in these cases, you have all of the statutory reasoning and the evidentiary reasoning of the special master that justified the decision. In addition, we've created a second annotation scheme, presuppositional types that capture the concepts, the entities, events, and relations that are important in these cases. For example, a specific vaccination. The vaccination, there has to be a vaccination with a covered vaccine on a specific date. Or a causal chain assertion, an assertion that a specific vaccination caused an instance of a generic injury. Or the assertion of a medical theory that connects them. So what's the context in which we think this kind of representation would be useful? We conducted a baseline study. We selected 10 cases in the VIP corpus, this vaccination domain corpus. 5 of them were won by the petitioner, 5 for the government. And then we used each case as a source case to construct a standard search query based on the facts of that case. We substituted values from each source case for the covered vaccine, the generic injury, and the onset timing, and we used 2 templates. The first one, Q1, was that the covered vaccine can cause the generic injury, and the second, Q2, the covered vaccine can cause the generic injury within a particular time period. These are simple queries, but not necessarily irrelevant. If an attorney is representing a client who, for example, had received the varicella vaccine and suffered an injury, and I can't pronounce this, I'll leave that to the medical personnel, but if they had suffered that, you can well imagine the attorney would be interested to see if there are other prior cases in this where these same injuries had been involved, to see what the outcomes were. So these are potentially useful factual queries. And I should mention that we're dealing here with evidentiary argument and evidentiary reasoning, not with reasoning about the rules and what the rules mean, but rather the evidentiary fact-finding arguments. So all of these cases, it turns out, are in Westlaw and Lexis, and so we provided the same queries to Westlaw and Lexis and recorded the results. Each of the programs provides a list of results. They're ordered in terms of the probability that they address the query need. The information need is represented by the query. And each also provides a case report where information is highlighted that, as far as the system knows, makes the reported case relevant to the query. And this is the Westlaw result, and the Lexis result is similar. And then you don't have to read the details here, but then we systematically ask some questions about the results from the IR systems. So in this table, you see each of the 10 cases. This is the first 5. The second column shows the query itself, the vaccine, the alleged injury, the time to onset. The third shows the total number of cases returned by the query. The fourth, the percentage of the percentage of the cases in the top 10 retrieved that were actual vaccine compensation cases. The fifth, whether the source case itself was in the top 10 by the query. The sixth, the percentage of cases in the top 10 whose case report had all 3 elements of query 1 or all 4 elements of query 2. And the seventh column, whether the source case report, wherever it was reported in the top 10 or not, whether the source case report has all 3 query 1 elements or all 4 query 2 elements. And we did that for all of the 10 cases. So let me summarize the results of our study with respect to these. First, the IR results lists, these retrieved cases in rank order. The goal is that searchers should retrieve the most relevant cases at the top of the rank-ordered results lists. And here, both systems did quite well. For all 40 queries, the percentage of returned cases in the top 10 was always at least 90%. Another goal is with respect to the source case, who you recall, whose facts formed the basis for the query. That should be among the highly relevant cases. And here, Lexis does a nice job. That's true in 75% of the time. Westlaw, not quite so good. It returned the source case in the top 10 50% of the time. How about the case reports? Like the results list, the case reports is some evidence of the knowledge, in quotes, that the information retrieval system has about how well this case is responsive to the query. For all of the 40 queries, results lists, we determined if the case reports for the source case and the top 10 cases included all the elements sought by the query. And the goal here should be that the source cases report, the source's case report should be Q1 and Q2 complete. That is to say, for Q1, it would have all 3 of those elements. For Q2, it would have all 3 of the elements plus the additional element of an indication of the time to onset. And another goal is that the top 10 cases should include at least some Q1 and Q2 complete case reports. We tried to be objective about this assessment. We adopted certain policies. We looked to see whether the report included a reference to the vaccine, either by the name or the well-known initials or by the commercial brand name and alternative. We looked to see whether it named the injury. For Q2, we looked for some specific time period. And regarding causation, the report should include an assertion or a direct implication that the vaccine caused the injury, and for Q2, that the vaccine caused the injury in a specific time period. And then we scored them. Regarding the source case, on 4 occasions, West's case report for the source case was not Q2 complete, even though the query was based on the facts of the source case. This occurred twice for Lexis. For example, West reported the Roper source case at rank 21 for Q1 and rank 11 for Q2, even though it was the only case of all the cases that the system reported that had gastroparesis in the results list. Regarding the top 10 cases, Lexis always returned at least 1 case in the top 10 whose case report was Q1 or Q2 complete, but West didn't find any Q1 complete cases in the top 10 for 3 queries or Q2 complete cases in the top 10 for 4 queries. And finally, we looked at the case report decision abstracts. This is what the an abstract, and you would expect that the case reports for the top 10 cases should make clear which side won the ultimate claim for vaccine compensation, whether it was the petitioner or the government, and which side won the causation sub-issue under the Alfin condition. After all, lawyers who are retrieving these cases want to be directed quickly to that kind of information. Who won overall, who won the sub-issue? For all 40 queries, the information about winners was much less frequent in the case reports in West than in Lexis. West reported the ultimate outcome 29% of the time, and the sub-issue outcome 47% of the time. Lexis did much better. I then had an inquiry. I asked someone I know at Lexis as to how these reports are generated, and it turns out that Lexis's reports are generated by humans, and West's generated automatically. So we can give credit to West for doing a pretty good job even with automatically created abstracts. So what? Our baseline study shows that legal IR systems return relevant cases with natural language queries and probabilistic criteria. They do a good job of that. But it also shows ways in which the IR system's performance is not ideal for argument retrieval. The retrieval precision isn't as good as it could be, as evidenced, for example, by the fact that the source cases are not ranked highly in the results lists. The case reports do not focus on retrieved case features that are relevant to the query. The decision abstracts do not make clear who won, what claims or issues. And our hypothesis is that we can identify and use semantic, presuppositional, and that default logic framework annotated information to do a better job, to make argument retrieval possible in a variety of ways. So for example, if argument retrieval can identify presuppositional information regarding the vaccines, the covered vaccine, the specific vaccination, then in a simple way it could address some co-reference problems. The cases refer to the vaccines in a variety of ways. They use their generic names, their popular names, their commercial brand names. Sometimes the vaccine is a composite of another vaccine. And if the program had information about this, then it could resolve co-reference problems. So for example, in the Thomas queries, the query was DPT vaccine can cause acute encephalopathy and death. The cases involving assertions regarding quadrigen-caused injuries might well be relevant because the DPT vaccine is a component of quadrigen. If argument retrieval can identify presuppositional information regarding temporal relations, like the specific vaccination, the injury onset, the onset timing, then it could perform some simple temporal reasoning. So for example, in the Wolf Q2 queries, neither West nor Lexis ranked the source case in the top 10 cases. The query was, hepatitis B vaccine can cause intractable seizure disorder after about 1 day. Wolf itself does not mention 1 day or day, but it mentions 12 hours in a sentence where it says that the injury occurred 12 hours after the immunization. That kind of simple temporal reasoning could improve precision. In the Walton case, where the query was the MMR vaccine can cause myocarditis after over 3 weeks, the cases returned referred to 3 test cases, all 3 special masters, 3 theories, several weeks of evidentiary hearings, etc. But the program could not figure out that those were not references to 3 weeks. If the AR system can identify presuppositional information regarding injuries, like generic injury and injury onset, then it could filter sentences in cases that are not relevant to reasoning about the injuries. The Sawyer queries sought cases involving injuries to the arm that might have been caused by the tetanus vaccine. The query was, tetanus can cause hand, wrist, and arm injuries at any time. The cases retrieved involve vaccinations in the right arm and the left arms, cases where there was a chronic arm problem, cases where there was where the vaccine was introduced into the arm, close, but no cigar. In addition, if the system can use that logical structure and pragmatic legal context captured in the annotations, not only the presuppositional annotations, but the default logic framework annotations, the system could focus on key sentences. Often, few sentences in a lengthy opinion capture the significant reasoning. That's probably an experience that every law student has had. The user argument goals make some sentences more relevant than others. For example, in these Q1 and Q2 queries, the purpose is fact-oriented. The attorney is trying to find cases that share certain facts with the problem situation. In the Casey search, the case reports for cases that West ranked higher than the source case itself from which the query was derived contained restatements of the Alton rule. Now, Alton was that Federal Circuit case that set out the general rule. Those general rules contain search terms, but no information about specific vaccinations, injuries, or durations. An argument retrieval system could distinguish sentences that restate the law from those that apply the law to facts. Using the default logic framework, rule tree showing the Alton rule, using the presence or absence of presuppositional entities and events, and using some analysis of the citation texts, because after all, appellate courts are the rule setters in this domain, often not the determining issues of fact. And finally, if the argument retrieval system can use logical structure in pragmatic legal context, it could rank cases more effectively and improve precision. Some information about the pragmatic legal context could improve the precision where a source case is only Q1 or Q2 is the only Q1 or Q2 complete case returned, but the source is still not ranked at the top of the results list, which happened repeatedly in our study. And finally, the argument retrieval system could generate more informative summaries of the case decisions, determining issues addressed from the annotated DLF structure and the presuppositional information, as well as the conclusion that was reached with respect to the issues decided. Well, how do all of those good things happen? We're just now working that out, but we're working on it in the context of some open source tools, unstructured information management architecture, or UIMA software components. And we're working closely with Eric Nyberg at Carnegie Mellon University, who's one of the developers of the UIMA tools. And we're using those tools to take the full text legal decisions regarding the scientific evidence of causation, extracting the syntax, extracting the syntax using a generalized UIMA type system, and then developing our own type systems for the legal reasoning as well as the legal discourse involved, extracting the argument-related semantic and pragmatic information, and using it to improve the information retrieval precision, to report the extracted arguments, and hopefully even to suggest new evidence and arguments. So this is our pipeline. And this is the LUIMA or UIMA plus our legal type system annotation environment, where we have indicated various types that we're annotating on the right-hand side, and we would expect and support annotators in annotating the texts by types, and then we're in a position to apply this information in improving the legal information retrieval results. There are some big challenges that we'll face. One is the attribution problem, determining the participant to whom the AR system should attribute the assertion. For example, a sentence that expresses the causal assertion might come out of the mouths of a variety of participants. It might be recounting an allegation in the case. It might be an entry in the medical record. It might be the testimony of an expert witness. Or it might be a finding of the special master as the fact finder. That makes a difference in how useful that case is in a subsequent argument. And one of the challenges will be to enable, through this legal discourse type system analysis, to give the AR system enough information to distinguish between those different assertions or attributions. And in addition, the presuppositional information that we want to be annotating here can be phrased differently from case to case. This is a problem that IBM has mastered in the Jeopardy-winning Watson program that it created, and we're hoping to use similar techniques to try to deal with it in our context as well. So this is definitely an area of open research, but we have framed it in a context where we have objective measures of how well we're doing, both in terms of improving precision and identifying key findings in a case, thus relating it to improvements in the task performance of the system. And we think that in addressing it in that framework, we can make a contribution to the existing research on extraction of legal information from legal texts. So that's my first example. The second example was one that I didn't expect to be involved with. Some folks at the School of Public Health had received some funding to comparatively study different states' systems for dealing with public health emergencies. And this group at the School of Public Health was interested in particular in statutes in which certain actor agents in the state's public health system were directed with some level of prescription to perform certain actions with respect to certain receiver agents in the system in order to achieve specified goals and purposes with respect to certain emergency disaster types in a particular time frame under certain conditions. And so they handled it in a straightforward way. They basically devised a coding scheme, and then they went and retrieved, using Lexis and Westlaw special searches, to retrieve all of the state's public health-related statutes, and they proceeded to manually encode them in terms of the public health agent, the actor, the prescription, the action, the goal, purpose, emergency type, public health agent, the receiver, conditions, and time frame. And they did this systematically for Pennsylvania and Florida and California. So for example, here's a Pennsylvania statute. If according to the statute on the left, if a local health officer finds a person with a communicable disease, refuses to submit to treatment, he can order basically isolation of the individual. This is the statute that gives that power. And they coded it. And they created a very elaborate coding table and filled it in for each of the statutes. Then they created network diagrams to represent the results of the coding. So here we see the Pennsylvania preparedness laws. The network diagram represents actors, state agencies, and other participants in a state's public health system. And the arcs indicate who is directed to do something with respect to some other actor. And sometimes the arcs are unidirectional, and sometimes they're bidirectional. And the weights of these arcs represent the numbers of the frequency with which these directions between two particular agents occur. Once you've done this, you can then compare regulatory frameworks with these statutory task network diagrams. So here we see a comparison of legislatively created legal networks in Florida and Pennsylvania for the purpose of radiologic nuclear incident surveillance. The circles represent the public health system actors and partners directed by law in both states. The tan links show relationships present in both states, and the blue links show relationships that are present in Pennsylvania but not in Florida. Also, I should point out that up at the far left, it shows the agents that are known but that are not in this system with respect to the preparedness laws. And since there's network diagrams, there are various measures of the features of network diagrams: density, inclusiveness, degree, strength. There are others that they could have used that they didn't. For example, in a weighted network, the strength is the total weight of the incoming and outgoing edge weights for the connections of each agent. And once you've got that, you can create a heat map of agent strength. Here's the strength of 29 public health system agents in legally specified networks for preparedness, response, recovery, and for all purposes. The heat map is scaled from minimum frequency black to maximum frequency white. And public health analysts can look at this and notice things. For example, here's that white dot for Maryland with respect to recovery, where everybody else has a black dot. In other words, they can analyze the networks to reveal certain patterns. Like in all 11 states, the network density is lower for purposes of recovery than for other purposes. Or across all states, the average strength of the public health system agents is greatest for response purpose and least for recovery purpose. And these patterns, which are evident in these visual representations on close inspection, suggest policy questions and hypotheses to check out. So with respect to recovery, for example, low density and inclusiveness of the networks representing these emergency recovery laws suggests the legislative change to improve community resilience by identifying and directing additional public health system agent types. Or Maryland's high strength of PHS agents and recovery laws could have implications for nearby Pennsylvania. After all, they're right next to each other. Why is there a difference? Or, despite their obvious roles in emergencies, strength of health care providers like community health centers, home health agencies, hospitals, laboratories, etc., were conspicuously low in these networks, not represented. The public health analysis folks look at these, see the patterns, ask the questions, and that then leads to investigations that they will make that could well be interesting. It's neat, but it all depends on very extensive and expensive manual encoding of the statutes. And so our task was, can we automate to any degree the encoding of the statutes? We tried basic machine learning experiment with respect to this. We took the provisions, we broke them down into chunks in a systematic way. We represented the chunks with a bag of words representation as feature vectors. We separated training data from test data. We trained classifiers for each of those 9 concepts on the training data, and then evaluated how well our prediction was against the test data. We compared that with 2 baselines. One baseline, the MFC baseline, was the most frequent code, determining the most frequent code for a given attribute in a training set and predicting it for the validation data. And the second was a little smarter. It combined most frequent code plus a set of signal terms from a manual coding dictionary. We evaluated the metrics in terms of precision, recall, and the harmonic mean of precision and recall, the F number. And we found that we were able to make a modest improvement over the baselines, especially for the multi-label tasks, where here in these, the green results are the results of the machine learning classifiers, and the yellow are the baseline. And with respect to the single label results, we had a little success with relevance. Machine learning produced a higher precision but a lower recall. Here, even though the green is below, what we're measuring here is classification error, so actually the machine learning reduced classification error. In other words, a little bit of success in trying to annotate the coding in an experiment that focused only on the Pennsylvania data. But we realized there was one big problem. They'd done all of this wonderful manual encoding, but they had, in a sense, separated the encodings from the context of the text in which the codings were made. So the codes here are often some Excel spreadsheet someplace, and we only know that they relate to this chunk, but we don't know exactly to what sentences or words or concepts in the chunk they relate. Ideally, they would have preserved that connection, and if they had consulted us earlier, we would have certainly gotten them to do so, but we came in belatedly. So we're thinking about how we can fix that. To summarize, directly applying the coding scheme from the School of Public Health is too coarse. So we're thinking about first annotating the plain language of the provisions in terms of general linguistic features, and then annotating it in terms of public health law specific features, agents, actions, and so forth, and then applying the PHE, the public health emergency coding. Our hope is that underlying the UEMA annotations will, that the underlying UEMA and LUEMA annotations will maximize the applicability of the coding across states' public health emergency laws, and that the machine learning can learn to associate different ways of phrasing with the PHE concepts. So to give that a little bit of an intuition, here's that same sample text from the Pennsylvania statute. We would annotate it in terms of the sort of premise part of the statute as well as the consequent. And then for each of the premise and the consequent, we would annotate it in terms of the public health agents, concepts, agent actions, properties of the agents and concepts, some kind of an abstraction from the public health coding scheme in that same kind of a LUEMA annotation environment, but this time where the types system has been tailored to this statutory domain, and see whether we can't improve on results in this area. There has been work, by the way, in both of these areas, network analysis as applied to law. Dan Katz, I believe, was the speaker in this series a little while ago. And work in automatically classifying statutory texts in terms of types or norm features or regulatory functions. But we are combining these two, we hope, for greater effect. Well, that's a lot of annotation of text. Who's going to do this annotating? I'm not sure the answer to this question, but law students come to mind. Law students need instruction in finding and closely reading the relevant parts of legal texts. I think any law faculty person would tell you that. The legal annotation types that I have been talking about reflect the conceptual elements of legal reasoning and argumentation and substantive legal domains, causality relations, proof standards, allegations, entries and records, testimony of expert witness, findings of fact finder. It's not such a bad thing to ask law students to do this annotation, especially if you provide them with a nice annotation environment. And indeed, law students in Vern Walker's Law, Logic, and Technology Lab were the ones who annotated the VIP cases in terms of the default logic framework for credit, and seemed to have benefited from it, or so they reported to Verne. And in addition, we're looking into using computer-supported peer review as a kind of quality control to ensure that the annotation is done well. So, in conclusion, I've shown you two examples to motivate the importance of integrating computational models and legal texts. I've tried to illustrate some of the challenges in my list of 5 at the beginning. Let me just more specifically indicate how I think the examples show some of these challenges. With respect to the VIP project, where we're improving legal information or trying to with argument retrieval, notice that we have created a context that has a practical outcome, the improvement of legal information retrieval searches, that integrates computational models of legal reasoning, but that doesn't require convincing Lexis or Westlaw that they've got to go and represent each of the cases in their corpuses in terms of the model of legal reasoning. Rather, the model is applied at the end to just those top 10 cases or top 100 cases. And that's where the model is used to improve upon precision. In addition, notice that we've identified a context where there are measures for evaluating how well the automated annotation works and how well the integration facilitates the task. We've got a gold standard to assess how well our text annotators are working, how well they find the key findings in the test cases. And we can measure the delta, the change in precision of legal information retrieval and the focus on those key text parts. And so we can show the benefits, if any, of our integration of the computational models. That's harder to do in the context of the public health project. It's hard to objectively assess the utility of these social network diagrams or of the contribution of the automated classification of the texts. But interestingly, the School of Public Health people have funding now and are going out to the public health agencies and showing them the social network diagrams relevant to their state's public health-related, emergency-related statutes, and showing them the sorts of inferences that can be drawn from the pictures and the heat maps, and trying to see whether the public health officials don't warm to the utility of the tool. And I think that's probably all I have to tell you. I've got specialized conclusions for my 2 examples, but I probably have covered everything I'm going to say here. One imagines after the triumph, or I thought it was a triumph of the IBM Watson project, that information extraction has moved to the point now where we can actually use it for legal tasks. And by the way, to the extent that we succeed, we're doing something that Watson couldn't do, which was to explain its answers, which has always been the contribution that AI and law makes to AI in general, focusing on explanation and argument. And so we're excited about that. But there is an enormous amount of work ahead for us with either or both of these projects. But I'll stop there, and I'm happy to take questions.
Any questions?
Well, thanks for the great talk. You mentioned this argument retrieval. And the argument, in my mind, is a set of conditions, inferences, and that's present in a legal case document. And now, from what I hear, I don't see the kind of argument that of match that description.
Uh-huh. Let me take you back. So this default logic framework, in effect, is instantiated for each of the cases.
Mm-hmm.
This is the statutory and court-made rule part of it. And then the annotations of the leaf nodes for each case provide the evidentiary findings of fact that the special master asserts satisfy each of those requirements in the leaf nodes. So a path from the top to the bottom is an argument.
That's right. Okay. Let's look at the lower leaf.
Yeah.
A logical sequence of cause and effect. Well, that's a natural language description.
Yeah.
And in your knowledge representation, you know, how this box of natural language is represented. Do you have an entity representing each concept of them?
It's represented extensionally. Not intentionally, but extensionally. In other words, the special masters, as they are deciding in each case whether there is a medical theory that causally connects, is finding certain facts that the special master asserts are a basis for deciding that, yes, there is a medical theory, or no, there isn't a medical theory. And one has this extensional representation of this for each of the cases where there was a finding. And that's information that, in a sense, fleshes out the meaning of this concept in a way that can be used.
So you need a human of a special master to utilize this extensional logic in a way. You cannot automatically automate a special master.
Well, we look at it this way. The special masters, as they're deciding these cases, are making these connections, fleshing out the meaning of this, and we create a computational context that can take advantage of it. So yes, you need a human. Fortunately, we've got them. Special masters, they're going to continue to churn out these things and these decisions, and we can take advantage. We can represent the decisions and take advantage of that information in improving information retrieval or argument retrieval or whatever.
Okay, thanks.
All right, well, I want to continue along that line a little bit. So, by the way, I really love this argument retrieval versus IR distinction. I think you're really moving the field in the direction it needs to move to higher level understanding of the structure of this material. This is, you know, this may not be the final step, but boy, is it an important step. And so kudos to you for really pursuing this. The thing I want to ask about specifically had to do with the sort of the what might be called ontology of the field. You talked about vaccines and injuries and diseases and so forth. And here you had your staff, in effect, developing that ontology. So here are a bunch of people, for the purposes of legal analysis, who are developing those concepts in that ontology. Now, that means effectively that if this is to be pervasive, that this community of legal and technologists are going to have to essentially create a theory of the world, separate from what the medical technologists are doing. And so my question is really, what if you were to take an ontology from the medical world and use it instead of one that you generate yourself? How would that degrade the performance? Would it still show useful utility?
Yeah, it's a great point and a great connection. And we have identified a couple of medical ontologies that provide ontological concepts with respect to vaccinations and these particular vaccines. And at this point, we're just figuring out how we can use them. But we definitely want to use them. And it will be a sort of, I think, editing of them for our particular task. Yeah.
It's coming.
It's coming,
Thank you.
But nice connection.
So you mentioned letting the annotation be done by law students, but another option would be to let the special masters and decision makers and drafters of the argument do it themselves by using tools that at least automatically generate parts of the annotation, especially for the argument diagramming. That is feasible. You could have lists of issues, lists of reasons for and against, annotating which remarks are evident, etc. What about the prospects for that?
Yeah. I think it all depends on the ease of use of the tools. We've compared the UEMA annotation environment to the GATE annotation environment. Adam Weiner, for example, uses the GATE annotation environment, and boy, it's a lot easier to use. Certainly, I think if we're going to involve law students, we have to get to the GATE environment. But I suspect that there's still yet a big gap between that environment and what you could ask a special master to use. But I'm in sympathy with the hope.
Thank you for a great presentation. I just have a couple of questions. First, your first model was not able to scale up beyond hundreds of documents. So is it because of manual work in it, or what was the reason?
Say the last part again. Was it because of?
Manual data entry. The first model only scales to 100 documents, not to millions of documents.
Yeah. So at 3 o'clock, I understand I'm going to be attending a meeting, and I'm going to give a third example. And the third example involves a program that my student did, the IBP Plus Smile program. And there the goal was to, she had created a program that predicts the outcome of trade secret cases based on a set of factors. Factors were stereotypical patterns of fact that strengthened or weakened the side's position in a trade secrets case. And she showed nice results with respect to the predictive accuracy. And then she tried to get her SMILE program to identify and extract the factors from the from short squib-like descriptions of the cases. And so my hundreds number came from her work. There were 185 cases there. And in that situation, it was from the sheer, this was work that was done about 8 years ago. It was from the sheer manual labor involved in doing the entry. We just stopped with 185. We had engaged some law students in helping us get that far, and we had to pay them to do it, and sort of time and resource. It was part of her dissertation project, and there were time and resource limits, so we stopped at that point. But I do think that we can, I want to revisit that project in the context of our work on Luima tools for annotation, and I think that we can streamline it. There, I think that the ingenuity is all probably, there doesn't need to be a whole lot more development work in the sort of intermediaries between the factors and the pieces of the model, these factors and the texts. And so I think we can make progress.
And the second quick question I would have is that it sounds that you have a specific algorithm or a state machine for a type of cases. So let's say if it's a vaccination case, so you have to design this kind of state machine by hands and then feed data into it.
Well, we need to identify the types. And the way the UEMA platform works, it's a hierarchical organization of types. This was from an earlier talk that I had given on the subject, and here we see a sentence: the varicella vaccine caused an inflammatory response. And the UEMA general type system that's sort of open source gives you things like the parts of speech tagging, various dependencies, frame projections like subject, verb, object, and so forth. And then we have to layer on top of that additional types for the presuppositional annotations and for the DLF annotations. And so it's a kind of creative activity of figuring out the right abstraction level for these different types so that they can be annotated in a kind of objective way, and then interpretations derived from them in an automated way. And I'm sort of just getting my feet wet in understanding the intuitions about the type systems. So I think this is where the research contribution, the immediate research contribution is.
All right. Well, thank you very much, Professor Ashley, for coming to us and for your fascinating talk.